Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Okay guys, this one is going to be a longer one than normally. I don't think I've ever done one that went over 40 minutes before, but this one is going to do that. So I just want to give everybody a fair warning. I do value your opinions and I do value your comments. So I'd appreciate it if those of you who are able to make it all the way to the end of this monstrosity, if you would answer the question I ask at the end about what you think the Supreme Court ought to do in this case. Today we are going to talk about E.I. duPont. This is E.I. duPont. You probably recognize the name. But today you probably wouldn't recognize them because they're actually doing an impression of Chicken Little. The sky is falling, the sky is falling. Why do I say they are doing an impression of Chicken Little? Because they filed a petition for certiorari at the United States Supreme Court over the result of a Sixth Circuit case. And in doing so, they made some claims that I think are a little outrageous and unlikely to succeed. At least they should be unlikely to succeed. You can never tell what some clerk and some judge on the Supreme Court is going to do in terms of putting this before the rest of the court. But my interpretation of the pleadings here and the amicus briefs that have been filed is that basically duPont is doing a lot of horribilizing and trying to stir up something that really has pretty much settled law. But we'll get into that here in just a second. What's this about? It's about Teflon. That's right. The stuff that's on this pan is at the heart of a lawsuit involving duPont and several different plaintiffs. Although Teflon was originally asserted to have been created for the space program, it was actually created in the 1950s, as we'll see here in a minute. But the creation of Teflon involves a chemical called C8, which is actually called PFOA. I could probably pronounce the actual chemical name if I gave it enough of a try, but I won't bore you with that. The bottom line is it's a forever chemical, meaning that once it gets in the water, it tends to stay in the water. Once it gets in your body, it tends to stay in your body. And once it gets in your body, it does some rather uncomfortable things. For example, giving you multiple different forms of cancer. Well, there was a jury verdict in a case, and duPont is appealing based on some perceived injustices. So let's take a look at what they say in their petition for certiorari. So this is a writ to the Supreme Court of the United States. It's basically a request from the Supreme Court to have the Sixth Circuit send up the file in this particular case. It's E.I. duPont versus Travis Abbott and Julie Abbott, the respondents. It's filed by a firm in Alexandria, Virginia. So here is the question presented. It says this case arises from a long-running multi-district litigation, which is actually incorrect, in which thousands of plaintiffs claimed injuries from permitted chemical releases from one of the petitioner's plants. They were only permitted at the time. They're no longer permitted. Some plaintiffs lived near the plant while others lived tens of miles away. Some claimed exposure via air, others via emissions, and claimed dates of exposure varied widely. Because of these differences, the damages claims proceeded in an MDL rather than a class action. As is common in MDLs, a few cases were selected for informational, expressly non-binding bellwether trials. After 3 trials resulted in plaintiffs' verdicts in cases not designed to be representative of all the MDL cases, and despite the court's assurances that verdicts would not be binding, the district court invoked non-mutual offensive collateral estoppel to preclude petitioner from disputing the key issues of duty, breach, and foreseeability here and across the MDL. That term, offensive non-mutual collateral estoppel, is a real mouthful. Let's take a look at an article here which tells us a little bit more about non-mutual offensive collateral estoppel. So this is from a Catholic University Law Review article from 1980, and I'm using it here because it very adequately describes what non-mutual offensive collateral estoppel is. It says collateral estoppel issue preclusion is like the related doctrine of res judicata claim preclusion. It's a common law rule limiting the relitigation of issues actually or necessarily determined by a judgment in a court of competent jurisdiction. Although distinct in operation, both doctrines have the purpose of judicial finality. From a policy standpoint, the application of these doctrines protects individuals from vexatious litigation and promotes the efficient use of judicial resources. At common law, courts developed the mutuality rule as corollary to these litigation doctrines. The rule restricts the use of collateral estoppel to cases in which the parties to the subsequent action were parties or privies in party to the prior action. So, non-mutual, meaning that in this case, DuPont was in the first three cases, but the Abbotts were not, and it's somehow unfair for the Abbotts to say that the issue was decided in the prior three cases. That's the non-mutual. Offensive means that they're using the results in the other trial as essentially as a cudgel against DuPont, saying you no longer get to contest these issues in our case. Collateral estoppel. In this case, it means issue preclusion. The issues of breach, duty, and foreseeability, which are all three parts of the negligence issue, those are not subject to being relitigated in this case basically because you lost it in the other three cases. The Sixth Circuit affirmed in a sharply divided decision. I think we'll see a little different here. The question presented is this: whether non-mutual offensive collateral estoppel can be applied to make the results of a handful of unrepresentative bellwether trials binding on the defendant in all pending and future cases in an MDL. Now, as I've mentioned before, an MDL is essentially a group of lawsuits that are put together and with the aim of getting everything worked out, hopefully in a joint settlement or a large settlement, and that's often what happens. And other times it simply means that the cases proceed to trial in an orderly fashion, sometimes taking decades to get through the litigation. So one way of speeding things up is to reduce the number of issues that are decided in subsequent cases. And one way to do that is through this issue preclusion. So DuPont is asking the Supreme Court to take a new look at the fundamental case, which is Park Lane hosiery, and it's also saying basically this is a denial of due process. So in order to put this in context, we have to know what the Sixth Circuit said when this appeal came before them. So let's take a look at that now. This is the opinion from the Sixth Circuit. Stranch delivered the opinion of the court in which Donald J. joined in full, and Batchelder joined in part, delivered a separate opinion concurring in part and dissenting in part. So usually when someone is in a sharply divided situation, sharply divided means that there was just a dissent and it was vociferous. In this case, that's not really the opinion here. That's not really the situation. But let's look at what the Sixth Circuit said. In the 1950s, DuPont began discharging vast quantities of C8, a forever chemical that accumulates in the human body and the environment, into the Ohio River, landfills, and the air surrounding its plant in West Virginia, contaminating the community's water sources. By the 1960s, DuPont knew it was toxic to animals, and by the 1980s, knew that it was a potentially human carcinogen. Despite these and other warnings, DuPont's discharges increased between 1984 and 2000. By the early 2000s, evidence confirmed that C8 causes several diseases among the members of the community's drinking water that had the drinking water contaminated. And that led to a class action lawsuit against DuPont. The parties went through negotiations and ultimately entered into a unique settlement agreement in which DuPont promised to carry out treatment of the affected water and to fund a scientific process that would inform the class members and communities about the dangers and harms from C8 exposure. In service of that process, the class voted to make receipt of a cash award contingent on a full medical examination to test for and collect data on C8 exposure. A panel of scientists then conducted an approximately 7-year epidemiological study and took blood samples and medical records of over 69,000 community members. The parties' agreement limited the legal claims that could be brought against DuPont based on the study's determination of which diseases prevalent in the communities were linked to C8 exposure. The resulting cases were consolidated in a multi-district litigation, an MDL. After 2 bellwether trials and a post-bellwether trial reached jury verdicts against DuPont, the parties settled the remaining cases. That did not end all the litigation, though, as more class members filed suit when they became sick or discovered the connection between their diseases and C8, including this case brought by Travis and Julie Abbott. At the Abbott's trial, the district court applied collateral estoppel to specific issues that were unanimously resolved in the 3 prior jury trials, excluded certain evidence from the trial based on the initial settlement agreement, and rejected DuPont's motion for a directed verdict. On appeal, DuPont challenges those 3 district court decisions. For that reason, and the reasons that follow, we affirm the judgment of the district court in full. So, the Abbott's case had its roots in the 1950s when DuPont began using C8 to manufacture Teflon products at its Washington Works plant in West Virginia. C8, or perfluorooctanoic acid, PFOA, no wonder they call it PFOA, is a synthetic organic chemical that is soluble in water and persists in both the human body and the environment. DuPont discharged it into the air, river, and landfills without limits until the early 2000s, as explained. So they had a Leach class action, and the class action settlement had a number of unique features to it. The Leach agreement fashioned unique measures to be undertaken over time to obtain scientific and medical information. The medical data that resulted from the examinations were used in a broad epidemiological study. And the Leach agreement also led to medical monitoring of diseases the science panel deemed linked to C8 for class members. The parties also agreed to a unique procedure that defined the parameters of legal actions the Leach plaintiffs could bring on the basis of the epidemiological survey. For each disease study, the science panel would ultimately issue whether there was probable link finding or no probable link finding. A probable link means based upon the weight of the available scientific evidence, it's more likely than not that there is a link between C8 and the human disease among the class members. In these lawsuits, once the science panel released its results, the right of individual class members to pursue their personal injury and wrongful death claims against DuPont was limited to the diseases with a probable link finding. In these lawsuits related to linked diseases, DuPont agreed not to contest general causation, that is, probable that the exposure to C8 is capable of causing a particular human disease, but retained the right to contest specific causation and assert any other defenses not barred. So, that was part of the agreement. That's what DuPont actually agreed to. So, in the MDL, there were 3,500 cases. The district court oversaw it and identified 20 cases for discovery, then narrowed that list further for bellwether trials. In guiding the parties' selection, both the parties and the court intended that the bellwether plaintiffs selected for initial discovery and ultimately trial reflect a representative sampling of cases which would provide meaningful information for the broader population of cases. You will note that DuPont called them unrepresentative. The Sixth Circuit made a finding here that they were reflective and representative, and as a result, that figured heavily into the decision. Ultimately, the parties proposed and the court accepted 6 cases, 3 selected by plaintiff's steering committee, 3 by DuPont, for bellwether trials. In the first bellwether trial, a case selected by DuPont, the jury awarded Carla Bartlett $1.6 billion in compensatory damages against DuPont for her state law claims related to kidney cancer. The negligence claim in the next trial was Freeman versus DuPont, and he developed testicular cancer, and he got a jury verdict. And then the plaintiff's steering committee selected the first of the non-bellwether cases to go to trial in 2016, Veneron versus DuPont. That case brought negligence claims, used the jury instructions on negligence given at the Bartlett and Freeman trials, and resulted in a jury verdict awarding $2 million in compensatory damages to the plaintiff. DuPont continued litigation in the district court as it appealed the Bartlett case, and it argued the district court had interpreted the Leach agreement in a way that made the Bartlett trial and all other MDL cases fundamentally unfair. They claimed the decision was a threshold contract interpretation error that eliminated the heart of a critical defense for DuPont in each of the $3,500 cases. But here is the kicker. In February after oral argument, but before the Sixth Circuit issued an opinion, they announced the settlement with the remaining MDL cases, including Bartlett, and withdrew that appeal. So if they had believed they had a winner, they could very easily have settled with Bartlett and taken the case on to appeal. But they didn't. And as a result, they got stuck with the results of the Bartlett trial. So the Abbott case came on, and Abbott developed testicular cancer. He has to take testosterone injections due to loss of both testicles. The district court scheduled the Abbott's case for a joint trial with that of another couple, the Swartzes, in early 2020. After rejecting DuPont's renewed challenges to the district court's MDL rulings, the district court granted partial summary judgment to the Abbotts on duty, breach, and foreseeability in their negligence claims based on collateral estoppel. The court further held that collateral estoppel precluded DuPont from relitigating the interpretation of the Leach agreement and its application to evidentiary issues, and 2, the inapplicability of the Ohio Tort Reform Act to Travis Abbott's claims. Now, the reason, it's probably not obvious here, so I'll spell it out. The reason the court they would not allow them to relitigate the interpretation of the Leach agreement is that they waived that issue by waiving their appeal. So, in terms of the MDL, the application of the Leach agreement and its interpretation are what are called law of the case, meaning you don't get to question that any longer. So, the month-long trial began in January 2020. The court instructed jurors that 0.05 parts per billion was a threshold level for general causation, but the specific causation was still an issue in the case. The jury found for both Travis and Julie Abbott, awarded them $40 million and $10 million in damages respectively, but later reduced Julie Abbott's damages to $250,000. The appeal in the Abbott's case followed, so they reach a number of issues here. And the first one, and probably the most important, and the one that comes up in the petition for certiorari, is non-mutual offensive collateral estoppel. Ohio courts generally apply issue preclusion when the issue was actually and directly litigated in the prior action, and a court of competent jurisdiction decided the issue. The party against whom collateral estoppel is asserted was a party in privity with a party or a party to the prior action, and the fact or point in question must have been actually and necessarily litigated and determined as part of the final judgment. And the party against whom estoppel is sought must have had a full and fair opportunity to litigate the issues in the previous action. In sum, Ohio's standard is very similar to the federal one. DuPont initially claimed that Ohio law forbids the use of non-mutual offensive collateral estoppel altogether. And by non-mutual, what they mean is because DuPont was in the prior cases but the Abbotts weren't, it's non-mutual. While the principle of mutuality is generally a prerequisite to the application of collateral estoppel, the Ohio Supreme Court has recently said, where a party clearly had his day in court and a specific issue brought into litigation with a later proceeding, the plaintiff can rely upon the doctrine of collateral estoppel to preclude litigation of that issue. Ohio is willing to relax the mutuality rule where justice would reasonably require it. So if Ohio's requirements are met, then we have to go to the Supreme Court's requirement in the Park Lane hosiery case. First, courts should avoid adopting it where it would encourage a wait-and-see attitude among potential plaintiffs. So that's not the case here because obviously they're in an MDL and nobody is in a wait-and-see attitude. Second, courts should not use the doctrine if the defendant did not have a reason to defend vigorously, particularly if the future suits were not foreseeable. Third, the doctrine should not apply if the judgment relied upon as a basis for the estoppel is itself inconsistent with one or more previous judgments in favor of defendant. Fourth and finally, courts should avoid the use of non-mutual offensive collateral estoppel if the later action would give the defendant procedural opportunities unavailable in the first action that could readily cause a different result. So then the court looks at application of the collateral estoppel issue to the negligence claims. DuPont points to a footnote in Benedictine in which it noted the Supreme Court's decision in Park Lane explicitly stated that offensive collateral estoppel could not be used in mass tort litigation. DuPont's interpretation of Benedictine, however, is inconsistent with the Supreme Court's clear pronouncement in Park Lane that the preferable approach for dealing with the fairness concerns regarding offensive collateral estoppel is not to preclude the use of offensive estoppel, but to provide broad discretion to trial courts determining when it applies. So basically, the trial court gets to make that decision. Ohio's collateral estoppel factors and the additional considerations delineated in Park Lane hosiery provide the framework for the district court's exercise of its discretion. The three prior trials were factually distinct. The Abbotts dispute the factual argument and countered that the use of collateral estoppel here served the core principles of judicial integrity and economy. So what does DuPont mean when it says they were factually distinct? DuPont says they're factually distinct in an attempt to say, hey, you can't apply collateral estoppel here because there's all these differences. Well, the Sixth Circuit wasn't buying that. We begin by determining whether the identical issue was actually decided in the former case. Factual differences do exist among the different cases, but the question is whether any of those factual differences are legally significant. DuPont claims that duty, breach, and foreseeability were unique to each plaintiff, given that each plaintiff was differently situated. For example, it says the Freeman and Vigneron plaintiffs argued that DuPont should have foreseen their injuries because C8 concentration in their water districts exceeded voluntary exposure guidelines. Abbott's water was below those guidelines. DuPont also contends that Abbott conceded that DuPont was unaware of his C8 in his water supply before 2001. Unlike the plaintiffs in Freeman, who asserted DuPont knew about it but did not warn them of the C8 in their water for over a decade. DuPont argues that these questions of duty, breach, and foreseeability were so closely tied to the individual plaintiffs that preclusive effect is impossible. Well, DuPont's argument attempts to ignore the fundamental principles that the pertinent factual issues for negligence claims in each trial revolved around DuPont's conduct and knowledge in relation to the Leach class members. Each jury received identical instructions on duty, breach, and foreseeability. Each jury found that DuPont owed a duty to the class members, breached that duty, and should have foreseen the injury that would result from the alleged breach. These are the actual instructions. This is the Bartlett one. And those instructions must and do reference to each specific plaintiff, but their focus and the focus of the jury's inquiry in each of the cases was on DuPont's conduct. The instructions state that a duty exists when a reasonably prudent person would have foreseen that an injury was likely to result to someone in Mrs. Bartlett's position from DuPont's conduct. The instructions and the law more generally peg the duty to whether a reasonably prudent corporation would have anticipated that its actions or inactions would cause injury. And for that reason, the court says, look, we're not dissuaded by these supposed factual differences. Put simply, these instructions turn on DuPont's conduct, not the particulars of individual circumstances. So we're not persuaded by DuPont's contention that the near factual identity on the water district and stuff is important. DuPont's emphasis on the factual differences between Trabbit and Freeman overlooks the factual similarities between them. So they go on about all the things that are similar, and then they look at the Park Lane hosiery considerations. We note first the Leach agreement created a limited closed subset of possible plaintiffs from the larger original Leach class. That was comprised only of people who had consumed contaminated water in specific water districts or wells for at least 1 year prior to 2005. The bargain for exchange that the Leach agreement established informs the application of collateral estoppel here. DuPont agreed not to contest general causation. We disagree with our dissenting colleagues' concern that it's fundamentally unfair to hold DuPont to the terms of the contract it negotiated and has received the benefit of, especially where DuPont has mounted multiple challenges to the district court's interpretation of the agreement to no avail. and then they cite a Fifth Circuit case, there's nothing fundamentally unreasonable about what BP accepted and now wishes it had not. In other words, DuPont, you made this bargain, now you got to live with it. Turning to Park Lane factors, we note that the first factor that the MDL gave DuPont a greater measure of power over case scheduling than normal cases. Second, the MDL structure presented DuPont with every incentive to defend itself vigorously. And third, there is no concern about inconsistent verdicts with previous judgments in favor of DuPont. DuPont was not successful at any trial, and in fact, they chose to settle the remaining bellwether cases with the plaintiffs. The fourth Park Lane factor, then, DuPont presented no evidence that had any procedural opportunities that could readily result in a different result. None of the Park Lane hosiery considerations weigh against the application of collateral estoppel in these circumstances. DuPont does not offer any cases that create a notice requirement for collateral estoppel, nor does it show that bellwether trials are prohibited from having such preclusive effect. See, for example, Sylvanch versus Celebrity Cruises, allowing an informal bellwether to have preclusive effect. In a similar vein, both DuPont and our dissenting colleague emphasized the applicability of Henry Chevron. That case involved a proposed trial vine for binding bellwether trials. These trials were never designated as binding bellwethers. Even were we to imagine a fairness issue related to notice, the record does not support DuPont's arguments. The district court did not promise that general assumptions of litigation, including that issue preclusion is possible, would not apply to the bellwether trials. The results of those trials would not automatically be extrapolated to non-bellwether plaintiffs. So that's how the collateral estoppel issue was litigated in the Sixth Circuit Court of Appeals. Did you notice the differences between what DuPont said in its petition for certiorari, basically what they said the Sixth Circuit said, boy, that's a tongue twister, and what the Sixth Circuit actually said? Now, I didn't get into Judge Batchelder's dissent here. You can read it on the Sixth Circuit website if you're interested. But it wasn't what I would call a sharply divided panel. There was some dissent as to whether this was actually fair or not, and it basically argued fairness, very similar to the way that DuPont argued fairness at the Supreme Court. But there is fundamentally nothing unfair about holding them to the deal they struck in the original litigation and applying issue preclusion to speed up the trials. Now, if you were facing a series of maybe 3,500 trials, or maybe you're going to have a group of trials that are going to come up in the years that follow because somebody develops cancer much later than the original discharges into the water, well, one of the things that you might want to do is you might want to slow those down. You might want to demand discovery. You might want to contest every single issue in that case. And basically what issue preclusion does is it says, hey, you can't do that. So now let's look at the amicus curiae briefs of the different parties. Now, the Product Liability Council and the Defense Research Institute and the Washington Legal Foundation, those are all basically associations of lawyers who get paid to defend big corporations. And they are coming in and like their hair is on fire and screaming that the sky is falling because this is a bad decision for them. This means that they get beat 2 or 3 times in an MDL, that they're going to have those decisions used against them if all these other factors are the same. I think there is enough different in this case, particularly the Leach settlement agreement. There is enough different here that it's probably not going to have, the Sixth Circuit opinion, is probably not going to have wide applicability beyond the Sixth Circuit. So I would think Norfolk Southern would be really interested in this outcome, but I didn't see a petition, or an amicus brief from Norfolk Southern. Nonetheless, this is what those amicus briefs say, and I would point out that just because you say you're an amicus, a friend of the court, it doesn't make it so. I think in more cases than not, the amicus is just a friend of the petitioner. And they're just, like I said, they're piling on to try and make a big scene so the court will take the case. Now, we haven't received the brief yet of the Abbotts, and I hope that the Abbotts brief will be pointed and get to the point of why the court should not take this. The review of these amicus briefs will give you some indication of exactly how corporations go about trying to join forces and defeat a bad set of laws that they feel have risen up through the courts. This is the brief of the Defense Resource Institute Center for Law and Public Policy and Lawyers for Civil Justice in support of petitioner. This is a defense industry and defense attorney group that basically always supports the defendant. I'm sure that they would have supported Union Carbide if they had been given half a chance. So they say the Sixth Circuit decision deprives DuPont of due process. That's something that essentially DuPont said. Even-handed justice in MDLs by upholding a district court's after-the-fact switch about whether bellwether cases would be illustrative, not binding, that undermines faith. It doesn't, because the district court never made such a promise. And the Sixth Circuit decision will destroy the utility of bellwether trials. Well, no, it just means you have to win the bellwether trials for you to get the benefit of them. The idea that it will destroy them is simply horribilizing. They are trying to paint this picture that the justice system will collapse on itself with all these MDLs. And that's just not the case. So you don't do bellwether trials. You just start taking them as they were filed and you start litigating them. And then guess what? You have a bunch of cases where the cases are decided against you and the court applies the non-mutual collateral estoppel anyway. So let's look at the next one. Now this is the brief of 3M, Bayer, GlaxoSmithKline, Johnson & Johnson, Tyco Fire Products, and Medtronic. And they are supporting the petitioner. And what do they say? Park Lane hosiery should not apply to MDLs. It has tenuous roots and conflicts with precedent, common law, and the Seventh Amendment. And Park Lane hosiery should not apply to MDLs. The Sixth Circuit decision conflicts with Park Lane hosiery. In other words, they are making essentially the same arguments as every other amici. And this is the brief of the Washington Legal Foundation as amicus curiae. And what do they say? Well, first of all, they say whether non-mutual offensive collateral can be applied to make the results of a handful of unrepresentative bellwether trials binding. As we noted earlier, the Sixth Circuit specifically found that they were representative. Duty, foreseeability, and breach are plaintiff-specific issues that are incompatible with non-mutual offensive collateral estoppel. Non-mutual offensive collateral estoppel is incompatible with mass tort cases. So, again, saying pretty much what you would expect them to say, essentially being the echo chamber for DuPont in this case. Now, again, if it's not just right on the tip of your tongue, the Seventh Amendment is the right to a jury trial. And in some respects, everybody, whether you're plaintiff or defendant, has a right to have their case determined by a jury. The way that the courts tend to get around this is to say, well, you had your rights attended to by a jury. It just wasn't this jury. It was another jury. They heard these cases. They heard 3 of them. And guess what? Their determination was that you lost. So in the Seventh Amendment argument, while it's novel, I don't look for it to necessarily be a winner in this case. And then we have the brief of the Product Liability Advisory Council written by Shook, Hardy, and Bacon. Now, the reason I get to poke some fun here is because Shook, Hardy, and Bacon is a law firm that was founded in Kansas City, and now they have offices all over the place. But they became very famous during the tobacco litigation, particularly the tobacco litigation against the states, because one of the reasons they got the job of being tobacco lawyers is because being in Kansas City, their hourly rates were a lot cheaper than lawyers in Philadelphia and Washington, D.C. Actually, these tobacco lawyers do a pretty good job of setting up some things that were not in the other amicus briefs, and I think you need to give them credit for that. First of all, they talk about the ripple effects on the judicial panel on multi-district litigation, restrictive impact on procedural innovations such as master pleadings, negative effects on crucial MDL discovery tools, falling domino impact on jury verdict forms, adverse impact on a transferee court's access to triable cases, It undermines MDL settlement resolutions, and it's undercutting important elements of cooperation. So again, all of these are the echo chamber for the people at DuPont. So you guys all know that I am a plaintiff's guy. I do mostly plaintiff's appeals, and I work for the plaintiffs. So I tend to take a little bit harder line against things like this than perhaps somebody in the defense bar would. And again, the defense bar is an honorable profession. They do good work. They are usually very good, very ethical lawyers. I don't think they, really understand that the key to appellate advocacy is telling the truth about everything and letting the chips fall where they may. They really tried to fuzz things up here a little bit with some of the characterizations like non-binding and unrepresentative. I think what they should have done in this case is say, the court found that they were representative, but we disagree, and here's why. One of the first things I learned from my old boss, who was the Chief Justice of the Missouri Supreme Court, was that if you want to have good success on appeal, you have to get caught telling the truth. And if you can get caught telling the truth 3 times, you have pretty much won the day, at least as to credibility, and you are going to be believed. So it's really a bad idea to fudge things when you are taking stuff in front of a court. But now that you've had the opportunity and you are doubtless free of bias, I recognize my bias. And as a result of that, you can find all of these briefs, all of these amicus briefs on the Supreme Court's website. You can find the Sixth Circuit opinion on the Sixth Circuit's website. And you can read all of that for yourself if you want to, if my summary of it here has not been sufficient. And I would really appreciate it if you would give me your take on what you think the Supreme Court should do. Should it clarify the law and explicitly state that this is not a bad application of non-mutual collateral estoppel? Should it clarify the law and say that no, absolutely not, they should never have applied collateral estoppel here? It's an interesting question, and to the extent that it might make things easier for plaintiffs in the future, I would kind of enjoy seeing the Supreme Court take the case and write the opinion that says there's nothing wrong with applying non-mutual offensive collateral estoppel in MDL cases. However, I don't look for that to be the outcome. If they take this case, I look for them to do exactly the opposite and say, no, this was a bad deal. So we'll have to wait and see. The conservative jurists on the Supreme Court are perhaps likely to be bothered a little bit by how this came out. The question is whether or not this is a significant enough issue for the Supreme Court to take it. And at this point, I just don't know the answer to that. So that's what I have for you today. As you go through your day today, remember that it's hard to tell, but everybody that you meet has something going on in their life that may be upsetting to them. And try not to judge when you get a snippy answer at the pharmacy or you get an ugly response from a clerk at the grocery store. As my mom used to say, you never know who had burned toast for breakfast. And that's a consideration that I think, being kind, we need to understand that people can have a bad day. And sometimes the very best thing you can do when someone is snippy like that and say, I'm sorry you're having a bad day. I hope your day gets better. Have a nice day and walk on. Be kind. If you have the opportunity, be kind. Don't honk at that guy that just cut you off. That's my tip for the day. Thanks so much for watching. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.